David Didel, petitioner, versus Court of Appeals, and Sharon Corpuz Didel, aka Jane Ibrahim, respondents. GR number 151867, January 29, 2004. Republic of the Philippines. Oppositor, respondent. Decision, penned by Justice Inarez Santiago. Petitioner David B. Didel met respondent Sharon L. Corpuz Didel while he was working in the advertising business of his father. The acquaintance led to courtship and romantic relations, culminating in the exchange of marital vows before the City Court of Pasay on September 28, 1966. The civil marriage was ratified in a church wedding on May 20, 1967. The union produced 4 children, namely, Beverly Jane, born on September 18, 1968, Stephanie Janice, born on September 9, 1969, Kenneth David, born on April 24, 1971, and Ingrid, born on October 20, 1976. The conjugal partnership, nonetheless, acquired neither property nor debt. Petitioner avers that during the marriage, Sharon turned out to be an irresponsible and immature wife and mother. She had extramarital affairs with several men, a dentist in the Armed Forces of the Philippines, a lieutenant in the Presidential Security Command, and later a Jordanian national. Sharon was once confirmed in the Manila Medical City for treatment by Dr. Lourdes Lapuz, a clinical psychiatrist. Petitioner alleged that despite the treatment, Sharon did not stop her illicit relationship with the Jordanian national named Mustafa Ibrahim, whom she married, and with whom she had 2 children. However, when Mustafa Ibrahim left the country, Sharon returned to petitioner, bringing along her 2 children by Ibrahim. Petitioner accepted her back, and even considered the 2 illegitimate children as his own. Thereafter, on December 9, 1995, Sharon abandoned petitioner to join Ibrahim in Jordan with their 2 children. Since then, Sharon would only return to the country on special occasions. Finally, giving up all hope of a reconciliation with Sharon, petitioner filed on April 1, 1997, a petition seeking the declaration of nullity of his marriage, on the ground of psychological incapacity, as defined in Article 36 of the Family Code, before the Regional Trial Court of Makati City, Branch 149. Summons was effected by publication in the Filipino Star Ngayon, a newspaper of general circulation in the country, considering that Sharon did not reside, and could not be found in the Philippines. Petitioner presented Dr. Natividad A. Dayan, who testified that she conducted a psychological evaluation of petitioner, and found him to be conscientious, hardworking, diligent, a perfectionist, who wants all tasks and projects completed, up to the final detail, and who exerts his best in whatever he does. On the other hand, Dr. Dion declared that Sharon was suffering from antisocial personality disorder, exhibited by her blatant display of infidelity, that she committed several indiscretions, and had no capacity for remorse, even bringing with her the 2 children of Mustafa Ibrahim to live with petitioner. Such immaturity and irresponsibility in handling the marriage, like her repeated acts of infidelity and abandonment of her family, are indications of antisocial personality disorder, amounting to psychological incapacity to perform the essential obligations of marriage. After trial, judgment was rendered, the dispositive portion of which reads, "Wherefore, in the light of the foregoing, the civil and church marriages between David B. Diddell and Sharon L. Corpus, celebrated on September 28, 1966 and May 20, 1967, are hereby declared null and void, on the ground of psychological incapacity, on the part of the respondent, to perform the essential obligations of marriage, under Article 36 of the Family Code." Accordingly, the conjugal partnership of gains existing between the parties is dissolved, and in lieu thereof, a regime of complete separation of property between the said spouses is established, in accordance with the pertinent provisions of the Family Code, without prejudice to rights previously acquired by creditors. Let a copy of this decision be duly recorded in the proper civil and property registries, in accordance with Article 52 of the Family Code. So ordered. Respondent Republic of the Philippines, through the Solicitor General, appealed alleging that Roman number 1. The lower court erred in granting the petition, despite the absence of a valid ground for declaration of nullity of marriage. Roman number 2. The lower court erred in declaring that the church marriage between petitioner is null and void. Roman number 3. The lower court erred in rendering a decision without a certification having been issued by the Solicitor General, as required in the Molina case. The Court of Appeals recalled and set aside the judgment of the trial court, and ordered dismissal of the petition for declaration of nullity of marriage. Petitioner's motion for reconsideration was denied in a resolution dated January 8, 2002. Hence, the instant petition. Petitioner contends that the appellate court gravely abused its discretion and manifestly erred in its conclusion that the 1. Respondent was not suffering from psychological incapacity to perform her marital obligations. 2. Psychological incapacity of respondent is not attended by gravity, juridical antecedents and permanence, or incurability, and 3. Totality of evidence submitted by the petitioner falls short to prove psychological incapacity suffered by respondent. The main question for resolution is whether or not the totality of the evidence presented is enough to sustain a finding that respondent is psychologically incapacitated. More specifically, does the aberrant sexual behavior of respondent adverted to by petitioner fall within the term psychological incapacity? In Santos versus Court of Appeals, it was ruled psychological incapacity should refer to no less than a mental, not physical, incapacity that causes a party to be truly incognitive of the basic marital covenants that concomitantly must be assumed and discharged by the parties to the marriage which, as so expressed in Article 68 of the Family Code, include their mutual obligations to live together, observe love, respect and fidelity and render help and support. There is hardly any doubt that the intendment of the law has been to confine the meaning of psychological incapacity to the most serious cases of personality disorders, clearly demonstrative of an utter insensitivity, of inability to give meaning and significance to the marriage. This psychological condition must exist at the time the marriage is celebrated. The law does not evidently envision, upon the other hand, an inability of the spouse to have sexual relations with the other. This conclusion is implicit under Article 54 of the Family Code, which considers children conceived prior to the judicial declaration of nullity of the void marriage to be legitimate. The other forms of psychoses, if existing at the inception of marriage, like the state of a party being of unsound mind, or concealment of drug addiction, habitual alcoholism, homosexuality or lesbianism, merely renders the marriage contract voidable, pursuant to Article 46, Family Code. If drug addiction, habitual alcoholism, lesbianism or homosexuality should occur only during the marriage, they become mere grounds for legal separation under Article 55 of the Family Code. These provisions, however, do not necessarily preclude the possibility of these various circumstances being themselves, depending on the degree and severity of the disorder, indicia of psychological incapacity. Until further statutory and jurisprudential parameters are established, every circumstance that may have some bearing on the degree, extent and other conditions of that incapacity must, in every case, be carefully examined and evaluated, so that no precipitate and indiscriminate nullity is peremptorily decreed. The well-considered opinion of psychiatrists, psychologists and persons with expertise in psychological disciplines might be helpful or even desirable. The difficulty in resolving the problem lies in the fact that a personality disorder is a very complex and elusive phenomenon, which defies easy analysis and definition. In this case, respondent's sexual infidelity can hardly qualify as being mentally or psychically ill, to such an extent that she could not have known the obligations she was assuming, or knowing them, could not have given a valid assumption thereof. It appears that respondent's promiscuity did not exist prior to or at the inception of the marriage. What is, in fact, disclosed by the records, is a blissful marital union at its celebration, later affirmed in church rites, and which produced 4 children. Respondent's sexual infidelity, or perversion and abandonment, do not by themselves constitute psychological incapacity within the contemplation of the Family Code. neither could her emotional immaturity and irresponsibility be equated with psychological incapacity. It must be shown that these acts are manifestations of a disordered personality, which make respondent completely unable to discharge the essential obligations of the marital state, not merely due to her youth, immaturity or sexual promiscuity. At best, the circumstances relied upon by petitioner are grounds for legal separation, under Article 55 of the Family Code. However, we pointed out in Marcos v. Marcos, that Article 36 is not to be equated with legal separation, in which the grounds need not be rooted in psychological incapacity, but on physical violence, moral pressure, civil interdiction, drug addiction, habitual alcoholism, sexual infidelity, abandonment and the like. In short, the evidence presented by petitioner refers only to grounds for legal separation, not for declaring a marriage void. We likewise agree with the Court of Appeals that the trial court has no jurisdiction to dissolve the church marriage of petitioner and respondent. The authority to do so is exclusively lodged with the ecclesiastical court of the Roman Catholic Church. All told, we find no cogent reason to disturb the ruling of the appellate court. We cannot deny the grief, frustration, and even desperation of petitioner in his present situation. Regrettably, there are circumstances, like in this case, where neither law nor society can provide the specific answers to every individual problem. While we sympathize with petitioner's marital predicament, our first and foremost duty is to apply the law, no matter how harsh it may be. Wherefore, in view of the foregoing, the petition is denied. The decision of the Court of Appeals in CAGR CV No. 60406, which ordered the dismissal of civil case No. 97-467 before the Regional Trial Court of Makati, Branch 149, is affirmed. No costs. So ordered. Chief Justice Davide Jr., Chairman, Justice Pon Aniban, and Justice Carpio, concur. Justice Aspuna, on official leave.